More likely than not, that 0.01% is all it takes to tip the scales of justice. Join us as Inner Circle legend Charla Aldous, Eleanor Aldous, and Caleb Miller walk you through the critical moments, big decisions, and bold strategies that win high-stakes cases and show you how to turn that 0.01% into a game-changing verdict. You're listening to the podcast where winning is more likely than not. Produced and powered by LawPods.
Hi, I'm Charla Aldous at Aldous Law firm. I think the firm comes after Aldous Law. And we are on another episode of More Likely Than Not, our podcast that we've been doing for quite some time now. And I got to tell you, I am thrilled to death to have my dear, dear friend, Mark Mandell, on this podcast. Hi, Mark.
Hi, Sean.
He is one of my heroes. He is the person that I call before I go to trial because he helps me lay out my case, figure out the case framing and everything. So, Mark, I would like for our listeners to just know a little bit about you. Tell us about where you grew up and what your life experience has been.
Well, first, let me just say that, there are some people that you're just a better person being around them. So that's Charla Aldous. I cannot tell you how honored I am that she would even think I have something worthwhile to say. So having said that, sincerely, Charla, born and raised in Providence, Rhode Island, smallest state in the country. I think probably the county you live in, it might be bigger than my state, but it doesn't feel like that when you live here. So it's a great place to grow up. We're right on the ocean. Everything here is dominated by the Atlantic Ocean. My dad was an engineer, professional. My mom graduated law school, never practiced. And I have a brother and sister. My brother was a lawyer, later in life became a rabbi. And my sister is a physician in New York City. He's in Massachusetts.
Is he an Orthodox rabbi?
Now he's conservative,
Okay.
and which is strange to me because when he was in college, he was like, agnostic, and he studied Buddhism. He had no idea, but
Total hippie dude.
yeah, but not with the looks, but by social viewpoint, sure. I just grew up as average normal kid. Always wanted to achieve something, driven, I guess. Tough in my family because I was the youngest and it was expected I would do something, But, I grew up in Providence, public schools all the way through until I went to law school. Went to college in Tuscaloosa, Alabama.
Wait, Mark, I did not know that. A Jew from Rhode Island went to school in Alabama.
Sure, sure.
How was that?
Well, my mom was born and raised in Birmingham.
Okay.
And when I was in high school, I had no awareness. I had no awareness. Let me leave it there. I knew I wanted to go away, and I figured there weren't many places that would be much different than from Rhode Island, more than Alabama. So my mom had, her roots there. So I went to Tuscaloosa, and it was great. I was there late 60s, very early 70s, long time ago. Not too long after it integrated. In fact, I could walk down the street and see the faded sign saying colored and white on the.
Are you kidding me?
No. It was
Wow.
5, 10 years after that, but you still saw the residuals. But it was a great experience. I mean, I loved it there. I learned so much. My junior year became vice president of the student government, had my own TV show, and then became acting president.
Wait, your own TV show?
Yeah, I had a TV show.
What did you do on that?
Well, when I was in college, that was when Cambodia, Kent State, Vietnam was going on. And I was one of the 5 people who led all the demonstrations on the campus. As a result of that, a friend of mine, his mother had her TV show on this, not university TV, actual Tuscaloosa TV. And she asked me would I host Friday nights, 5 to 5:30. So I would bring on my friends. I'd say pretty fair to say half the people who watched loved us and half the people hated us. There wasn't much apathy about my program. So I went to school there and then went to law school in Washington, D.C. at Georgetown. That was a great experience too. I was there during Watergate. Most of my classmates came from, Harvard and Yale and that stuff. and I was from Alabama, and I was just trying to survive. But I learned a lot. I worked hard. I studied, worked. I had a full-time job my first year and a half and law school. So I learned an awful lot and knew this was what I was meant to do, you know?
I just love it. From Rhode Island to Alabama to Georgetown.
I know, I know.
I mean, that is quite a difference experience in
It's
life.
totally different. Totally.
You got something from every one of those places you
Absolutely.
went.
Yeah. My whole life I've tried to, I mean, since I was aware of making choices every day, first thing I got up to you know, to when I went to sleep, I tried to get as much as I could out of the day. So I would go to sleep tired every night, but I didn't see a reason not to.
You are a little intense. Did you know that?
Yeah, I think somebody once told me I was the most intense person they'd ever met. I think that's probably true. Although, Charlie, I've mellowed like 30 years ago. As one of my daughters-in-law says about my son, he tends to run hot. Yeah, so I probably did, I probably did.
That you mellowed since I've known you.
Yeah, yeah, yeah. I think I have. I think I have.
And I gotta say, you are intense, but I give that as a great, great compliment.
Well,
So tell us about this, Mark. After you graduated from law school, talk to us about your career, what you
well,
did.
I came back home. My mom died, so I came back home to because my
I'm
dad
sorry.
was alone. My sister and brother were off doing.
And that would be back home to Rhode
I'm
Island.
sorry. Exactly. Back home to Rhode Island.
Okay.
Clerked for a federal judge for a year, and then went to work with a lawyer here who was a plaintiff's lawyer, and we founded the first plaintiff's firm in Rhode Island back in 1974, 75, and was there 5 years. Then set up my own shop in 1980, and I've been practicing in our law firm here. I'm blessed, Charla. I have three partners. One's my wife, one's my son, and one is another young man who is very close to us. I love the people I work with. We have 8 lawyers. They're great lawyers. So I've been working in the trenches hard for over 50 years. Yeah.
But what's amazing, Mark, and I know this from our conversations, you love it.
Can I just say that I do love it? And in addition, it's not even a matter of a feeling, it's just who I am, just like you. I mean, I love your passion. I love your skill. But people can have skill. It's the passion that separates good lawyers from great lawyers, and you are a great lawyer. And so it's just who I am. It's not even really a choice. I do what I do because I absolutely, totally, 100% believe in what we do. And that's why I'm still doing it.
I know you do, Mark. I mean, every time I talk to you about a case, I can feel your heart and your spirit in it. It's not a vocation for you, it's a
Yeah,
calling.
it's a way of life. It's a way of life. Just like for you, same thing.
I know.
I think that's one of the reasons why we hit it off so well.
Sometimes I think it's a curse, but it's also a blessing because you know what? What we do, it feeds my soul. It really
Absolutely.
does.
Of course. Of course.
Sometimes I think I want to make a bigger difference in the world, but then I think if I can make it one case at a time for one client at a time, then I hope that's
A
good.
100%. I can't agree with that more.
Okay, so you decided to go to law school. Why?
Well, everything I'd ever learned, well, several reasons. Everything I'd ever observed told me I wanted to be a lawyer. Abraham Lincoln was a hero, and he was a trial lawyer. Probably most importantly, my mother was a lawyer, graduated law school in 1941, so way ahead of her time.
I didn't know that in 1941 your mother graduated from law school.
University of Alabama. Yeah. And the most amazing thing is,
Wait. 1941, a woman graduated from law school
yeah,
in
and I
Alabama.
actually have a picture. It's one of those scroll out long, narrow pictures of her graduating class. And Charlotte, in her graduating class was George Wallace
Oh my
and
gosh.
probably the best federal judge who has ever sat on the bench in the United States. He was a civil rights judge named Frank Johnson from Montgomery, Alabama. They were all
Absolutely.
classmates. They were classmates. Yeah.
With your
Yeah,
mother.
yeah, yeah, yeah.
How many women were in her law school class?
Well, so I don't remember, but I can tell you for some reason, I think there were two, maybe three. There were very few. It was all guys, all white guys.
She's up there with Ruth Bader Ginsburg. I mean,
Well, no, but she was my mom's
no,
mom.
what I'm saying is for us, for we women who are still dealing with sexism in the profession, to think that your mother went to law school Alabama in 1943,
41. Yeah, graduated.
41.
And
That's pretty amazing.
but the thing is too, and it's sad, she never practiced because she did what women did back then. She followed my dad after she went to law school. And just before she died, she was planning to reapply, go back. She already had her degree, but go back and practice. But then she died.
Mark, why did she not practice? Did she wanted to stay home and
Yeah, it was a different time. And then my brother was born in California. My dad went out in the U.S. Army Air Force to California. And so she wanted to raise the three of us.
it was what is expected of women?
Yeah, but look, I am where I am, largely in part to my mom. So I'm forever grateful.
Do you think she ever regretted not practicing?
I don't think when we were kids, because there was so much love in our house. I think when we were grown, I think she did. Yeah. I think she not regretted having us and raising us,
Right,
but
right.
that she never pursued it. Yeah, I think she did.
Because I got to tell you, Mark, as a mom, I mean, practicing law and being a mother is not easy,
Oh, no, of course. Of course.
especially my kids who are grown now. They sometimes say, "Mom, how did you do it?" And I said, "Well, I figured out early on I couldn't give you back, and you liked food, shelter, and clothing." Because I was a single mom, and I'm like, "Okay, this is how we do it." You get on the treadmill and you do what you've got to do.
Yeah,
So the reason you went to law school is because of your
yeah,
mother,
absolutely. She
basically.
inspired me. Yeah.
What was her name, Mark?
Her name was Frances.
Frances Mandell.
Well, yeah, she was after she got married, right? Yes.
What was her maiden name?
It was Friedman. I told Rick Friedman we might be related, actually. Not sure,
I
not
love
sure, but you know.
I love it. Okay, so you went to law school at Georgetown, which is obviously a very good law school. How did you fit in at Georgetown? It seems a little highbrow. I mean, because you're so down to earth. How did that work?
Oh God, I will tell you, Charlie, it was hard. It was hard, but I worked. I had a job, and I had
Right.
a job with a pretty well-known civil rights lawyer named Phil Hirschkopf, and he handled cases like desegregating the prison system in Virginia. And he actually, shortly after he got out of law school, argued. I believe he's the one who argued a very famous U.S. Supreme Court case called Loving versus Virginia.
Are you kidding
Yeah,
me?
he worked with a guy named Bernie Cohen, and I'm pretty sure it was Phil who argued it. So it was very hard for me because the law school was so competitive. Now I am intense, so I'm intensely competitive as well. That was brutal because these kids, they all wanted to go work, almost all on corporate firms in Wall Street. So that wasn't me.
Right.
So I was distinguished that way.
You knew you didn't want to go
Oh,
to a Wall
no,
Street
no
firm.
way. No way.
Okay.
No way.
All right.
I knew from the beginning that wasn't me. Not critical of it, just not me.
I gotta tell you, my daughter Eleanor and Caleb are both on this podcast that they're listening to it, and they're chuckling with some of the things you're saying
Well, that's
because
good.
it's
That's good.
so in Georgetown, you made your way
I did. I did.
on your
I
own.
did. I became president of the Student Bar Association in law school.
Wait, are you kidding me?
No, no, that's
Well,
just
then you just didn't made it. I mean, you were
no.
the bomb.
I gave the graduation speech at my law school graduation, and it was in 1974, and it was right at the end of Watergate. And they had, like, I don't know how many people there, all the kids' parents. And I dedicated my entire speech was around the lack of ethics in the Nixon administration. I thought I might get in trouble, but because I didn't have my diploma, I got it. I was so thrilled when I finally got it as I was walking across the stage. I wasn't going to not be me. That was just what I was going to do.
Hey, Mark, is that speech recorded anywhere?
I doubt it. It was 1974. And honestly, the only thing I can remember was I remember talking about the Cooper Church Amendment. I think it was the one about Vietnam. And I just I mean, I wasn't crazy, but I was passionate about what was right and wrong, and that I thought Nixon and what they did was just all wrong.
Just give us a flavor of what the speech was like.
Oh my God. Well, the only thing I can tell you was that not many of the parents stood up and clapped at my entire class did, though. My entire class of hundreds of kids, to my memory, stood up and clapped. But they were all
They
used
did?
to me anyway. They were used to me. But they knew I would be reasonable. I wasn't like when I was Georgetown's a Jesuit school, and I met a minister, Jesuit priest rather, and I wanted in 1973 to do a blood drive for the Israelis who got killed in the 6 Day War or 7 Day War in 1973, I think it was. And I was passionate about that. And this priest said to me, in God's eyes, Muslims are human beings, people, everybody deserves to get some of that blood, not just Jewish people. I listened to him and I realized he was 100% correct. And so my classmates knew that, I would be passionate about what I did, but they also knew that I really wanted to do it the right way. So they stood and most of the parents did not.
I really wish I could hear a recording of that
You
speech.
probably would have smiled at me.
No, I know I would have smiled at you and then I would have hugged you. Okay, Mark, I got to tell you, your groundbreaking work in case framing has, and I'm not just saying this because you're here, has changed the way I try cases, the way I look at cases, the way I develop cases. So I want to talk to our listeners about case framing. You have 2 books. One is case framing and the other is advanced case framing. Am I right?
Correct. That's right.
Tell us, how did you come about developing this body of work? And I'm going to tell every reader here, if you want to be a better lawyer, buy the books. Case framing, advanced case framing. Should they buy both or just the advanced case framing?
Since I give all the royalties to AAJ because I believe in their mission, I'd say buy both.
Okay, then let's buy both. Okay, tell us how you developed it, Mark, because it is fascinating.
Well, when I was young, Charla, I tried case after case after case, and some of them were, you know, 2 or 3 day trials. I mean, small cases. But I tried a lot of cases, and so that was in the 70s and 80s. I was very lucky. I mean, I was very lucky in results. And then in the 90s, things changed in the country. At least they did where I tried cases. I still try cases. But I noticed that there were some cases that I thought I should have won that I lost. And I noticed that there were some cases that I did win that I should have got more. And I think one trait you and I share is that I think we're both really hard on ourselves. And I'm my own worst critic, I'm brutal on myself. Not brutal, but I'm very tough on myself. I was so upset with myself. Like, I haven't lost a lot of cases, but most of them were around that time. And I just decided I needed to understand what I was doing. I've never enjoyed doing something without knowing why I was doing it. And when I grew up as a lawyer, I listened to people, and I don't mean this negatively, but the word sounds negative. I would go to these seminars and I'd listen to people pontificate about what I had to do, what we had to do. And honestly, none of it fit, very little of it fit me. It's like one guy, a great lawyer, allegedly, and I'm sure he was a very fine lawyer, said, I tell my jurors what to do. I tell them what to do. And I thought, yeah, I'm not going to tell my jurors what to do. I may inform them what to think about and then walk with them through that door, but I'm not going to push them through that door. You know what I mean? And that's just my failing, maybe. But so I decided I wanted to find out what was happening. And so I started studying it, like I try to study everything. And I ask a lot of questions. And so I came up with different ways to try cases.
When you say you started studying it, what did you study?
Okay. I became aware of what's called decision science, which is a science as much as any other science. It's just the science of how and why people make decisions.
Did you say decision
It's
science?
called decision science, yeah.
I've never heard of it.
Well,
Okay.
it's sort of like neuroscience. It's got basis in that and consumer science, but it's decision science. And so I started reading a lot about that in the 1990s. And two of my very close friends, Greg Cusimano and David Wenner, we worked together studying that. They came up with a model, and they asked me to come into it. And it's their model, not mine. I mean, but I did try to enhance it if I could. And so I came up with literally different models to try cases. And the first one was called the Circle of Proof, and I had 12 parts to it, and then I found the holes in that, and I was so disappointed. And then I came up with what I call choice theory, and I think there was a lot of validity to that, but I found the holes in that. And I was supposed to write a book on it with a law professor from Wake Forest who became a very close friend of mine. And I couldn't figure out what eventually I became aware of to call echoes because I couldn't figure out that concept. And then I started understanding through my trials because I tried a bunch of cases. I always tried to understand why, because I also made a lot of mistakes, and I tried to figure out why and what I could have done better. And then I would test that, and then I would do it again. And gradually, enough people, including jurors, said things to me that I began to piece together case framing. And I'm so thrilled. I really am because, people said to me, Mark, don't write your books, don't share it. The defense lawyers will find out about it. Wait till you retire. And I said, no, we're all in this together. We have to help each other out. I mean, if I have this consciousness, then I need to share it because that's what I should do. And I haven't found any holes in it. That's what I'm so thrilled by, Charlie.
Let me ask this, Mark. When did this investigation and your journey start, and when did you come to the case framing idea?
I would say I started in the 1990s, and I don't remember when. I'd say mid 90s. And I first tried it in a trial in 2006, February, and got a really nice verdict. And I said, holy, to the point, Charlie, where it's as you know, it's comprehensive. It is meant to include everything we do preparing and trying cases. And I got so immersed in it that now I won that trial in 2006, largely because my client was a beautiful person. And I learned for the first time that it wasn't about me. It's when I was able to understand it wasn't about me, but it was about what I was doing that I opened up and was able to let that consciousness into me to the point where the jury was out for 3 days, maybe 3.5 days. And I honestly felt for the very first time that I had a pulse on what that decision making process would be in terms of timing. And Yvette and I, my dear wife, who is my law partner, who we went out to lunch. And as we were driving to lunch, I said, Eve, the jury's going to come back by the time we finish. And they did.
Have you ever had a pulse like that?
Never in my life, ever. But you know what? I've had it since.
Oh my gosh, I've never had that. I want that.
Let me tell you, I just immersed myself into case framing. And I think I attribute that to that. But yeah, I mean, I still get nervous as all get out when the jury's out. And the first night, invariably, I'm torturing myself that I should have done this better and this better. And then, unless the jury comes back before then, but usually then I say to Eve, I think it'll be today. I think it might be not the minute. I can't. That's ridiculous.
Right.
But the day, I think I have at least a sense for it. But anyway, I really tried that. And then in 2010, I started completely using it. And when I first started lecturing about it in about 2011 or 12,
Wait, 2011 and 12 or when you started lecturing about case framing?
correct. Maybe it was a
Wow.
little before then, but it was about then. And one of my friends said to me, "Do you really do this?" Because part of it, none of it, it was all mine. It was all genuine to me from my whatever brain, whatever. And some of it was really counterintuitive, like don't say your case frame until closing,
Right.
or use the same sequence with every witness of your I just can't get over issues. It was so counterintuitive or counter what was taught for forever that one of my friends said, "Do you really use this?" So I sent him my closing argument in that case. That was in 2012. And he wrote me back and he said, "You actually do use this." And I said, "Yeah." I said, "It changed my life. It's changed my practice." So that's how I came up with it. But it applies to everything, because it coordinates everything.
Here's what I really want our listeners to understand. We talk about case framing. Mark, what is it? talk to us about the basic principles of case framing,
Okay.
because we want the lawyers who are listening to this podcast to understand how it will absolutely change their practice.
Well, I'll do my best. Okay. When I first published my first book, I was asked by the publisher, you need to state case framing in one sentence. And I said, I'm not smart enough to do that, but I'll make an effort, you know. And what I came up with is in my first book and my second book. And so the one sentence is just results occur when everything we do at trial, everything we do is to focus the juror's attention on the points we most want to make. And when you think about it, why would you want to do anything else? Why would you want to focus it on the points you most don't want to make? And I remember when I was young, I was so insecure, because I wanted the jury to like me, I thought, well, let me be disarmingly honest or open. And I would start my opening statements trashing my own case, saying, let me tell you, so you know this. And then I realized that was like the worst thing I could do. And then I would start my opening statements. It was in vogue to talk about how badly injured my client was. And then I realized the last thing I wanted to do was focus on my client at the beginning of opening statement, unless liability was conceded, and I accepted it. And then I realized that you need to start opening statement with the defendant's wrongdoing. Put the focus on them because the jury knows they're there. They know why they're there to make a decision. And so what they're looking for, from my perspective, from the get-go, is who was wrong. And so why would I want to put my client's image in their mind when they have a blank slate? And so what I do is I put the defendant in their mind immediately. And the reason I do it in the same sequence all the way through trial with every single witness is because I start with the best issue for me in the case, my key I can't get over issue, good for me, with an opening statement. First thing I talk about after I thank the jury. And actually, I don't even thank him in opening. I thank him in closing. I start with my best issue, and then my second best, third best. And I only get to inoculating against the bad issues after I finish all my good issues. And I do that with every witness, and I do that in closing. I say my case frame first after I thank them, and then I do that. And the reason why is because I want the jury to use that process in deliberations. And if it's comfortable to them and familiar, they will.
Let me ask you right here. You said you say your case frame first. What does that mean? This is fascinating to me.
Okay, so I thank the jury in closing. And me, much less than you, live sincerity. You do it much more than I do. But it's in my essence to be sincere. I'm not saying, oh, I'm wonderful, because I'm not. I'm totally fragile. I'm not, I'm no better than anybody else. But so I thank them sincerely at the beginning of the trial. That's what Rick Friedman does. That's what you do. It's what the very best lawyers, most successful lawyers in the country do. They talk from their heart and their soul and their spirit. And so I do that. I try to do that. And not because it's strategic, because that's who we are. So anyway, and then what I'll say to the jury is I'll tell the jury, which they have never heard before, how everything that they've heard so far ties together into the heart and soul of the case. And that's the overall case frame. And what an overall case frame is, what case frames are, and at their essence, is their filters. Everything we learn in life, everything we see in life, we see through filters in our brain and our consciousness. And for example, if you're a Trump believer, you will hear a set of facts and you'll filter it through your predispositions, how you see the world. Some of that is shaped ongoing by different news networks, but that's how we make decisions. So I use filters. I create the first filter by stating the best issue for me in the case, because
Okay.
I want the jury to look at the facts of the case through the lens of that binoculars, which is my best issue. All right. So what it does is there are two kinds of filters. Those that you say at the beginning and ongoing, so the jury sees all the evidence through that filter. And then those that you say at the end, when you say your case frame, overall case frame, and secondary case frames, And what they do is there are things after that that you see through that filter, but they take everything that happened before that and bring it together with that answer one question, because that's what overall case frames do. They answer the question of why. Why has this happened? Because what we did when I was a young lawyer, and everybody does it, and we need to do it, we have to tell the jury what happened. So we need to do that. But what jurors really want to understand is why what happened happened, whether it's a bad track record, whether it was incompetence. And if you look at every case frame, the 24 or 25 I have in my two books, because I never understood them before. People said to me when I was a young lawyer, look for the larger than life issue in the case. And honestly, I could never find it. And I was pretty down on myself, except for personal responsibility, because they use that against us pretty much every time.
Right.
But they're everywhere, Charles. These overall case frames are everywhere. And so I started realizing the very first one I got, and then I said, oh my God, I didn't say that, but I can't say what I said to myself on the podcast. But I said, oh my God. And what it was the O.J. Simpson criminal trial, because it was around that time or shortly after that. And I said, maybe it was a little more than shortly after that, but I said to myself, all right, Mark, what is it that this case is all about? And I said, well, is it Johnny Cochran's brilliant one-liner? If it doesn't fit, you must acquit. Or was it police misconduct? Mark Furman was a racist. He planted the glove. Or was it rush to judgment? And then I realized it wasn't any of those. They were one-liners I call I just can't get over issues.
Right.
But what I did was I realized, I said, how am I ever going to find the heart and soul of the case? How it all ties together? And when I asked myself that question, I said, okay, ties together is the key. So between those three, I just can't get over issues. If it doesn't fit, you must acquit, rush to judgment, and police misconduct. What runs through all three of those? Because neither one of them applies to everybody. I mean, how many people have tried to put on a bloody glove and it didn't fit because it shrunk? One person that I know of, not the whole society that's going to be on that jury. And so what I realized was it was wrongful accusation. Because of a wrongful accusation, the glove didn't fit. Because of police misconduct and a rush to judgment, there was a wrongful accusation. And everybody, you, Charla, me, everybody in this world has been wrongfully accused of something. It might be something as banal of when you were a little girl, you ate the cookie, not your brother, or something like that. It could be totally benign, but well, let me tell you, no matter how benign that wrongful accusation is, it stings to the person who's accused.
You don't forget those things.
So that's when I first said, oh my God, that's how these good issues come together. And a juror gave me, I mentioned in one of my books, gave me the blessing of understanding, because one issue that I think was case decisive in a trial I got a decent verdict in, I was in 2010. I talked to him afterwards and he was very nice. And then he said, I asked him about the failure to do x-rays before surgery. Did that make a difference? Even though I knew causally it didn't. And he said, we knew it didn't make a difference, but we just couldn't get over the fact that he didn't do them. And then I realized whether or not it's relevant or not at all, the causation, that's how people make decisions. So I then looked for those I just can't get over issues, looked at the thread of meaning that ran between them, and came up with case frames. And then echoes was the hardest part because I couldn't figure that out ever before. My friend from Wake Forest, Carol Anderson, who is the trial ad professor, is a really great professor. She called them choice markers, but that isn't me, so I couldn't feel that. I couldn't understand that. And then I realized what we're trying to do is we start with our I just can't get over issues. Certainly most of our time at trial has to be focused on giving to the jury our best and good I can't get over issues, and then also the best arguments to overcome the bad issues, that is the defense's best issues, and then they will carry us through trial. And there are very legitimate reasons, 5 I've come up with that I mention in my books, as to why you wait till closing argument. And then when I say it at first, bring it all together as to what happened and why it happened, they can't contradict it. All right. Because, I mean, they may have if you have a rebuttal, but even then they can't contradict it because if it's a rebuttal argument, I say it in rebuttal. In Rhode Island, I go last. So
Right.
there is no rebuttal. They go and then I go. So when I say it, they can't contradict it. If I were to say in the opening statement, this case is about a doctor who didn't know his limits, the whole trial, they'd be fighting that, showing how he knew his limits and how this and that. So I want to wait till they can't respond. And so I say it then in closing because
Wow.
so
I
anyway,
love that.
so it all came together, but it's everything. For example, like there are certain in echoes in my book, you'll see that I've come up with like 31, 32 ways to 30 different kinds of echoes. And some of the echoes are echoes that affect the process. So what I mean by that is I will never keep an alternate on a jury. No, I won't. In Rhode Island, we have 6 jurors. It has to be unanimous with 2 alternates. Judges always ask, will you keep the alternates? Because they don't want them to have been there for nothing. I did keep an alternate once, and I got a decent verdict, not 7 figures, but close. But then I talked to 2 of the jurors afterwards, and they said, we would have given you 10 times that, but for this one juror who was the alternate.
So why don't you keep alternates?
Because if I need a unanimous verdict, it's harder to get 7 than 6.
Okay.
It's harder to get 8 than 6. And yes, maybe that seventh or eighth would help me, but I'll never know that. You can't tell because somebody smiles at you. They just may like you, but that doesn't mean they're going to vote for you. You know what I mean? So I would have to really dislike all of my jurors for me to let an alternate sit. And if I dislike all my jurors, that means I did a crappy job and voir dire. Or I shouldn't say I didn't do a great job in voir dire.
Or the law didn't allow you to do a good job.
Well, whatever. But you know what I'm saying.
Exactly.
Yes, that's right. So, but that's not content so much. It's not sequencing so much. It's not framing, although it's all about framing because it is in a sense. What it is it's getting an understanding of the process the jury's going through, providing the right content, providing the right framing of that content, providing the sequencing that has to exist for that frame content, and then framing the process. That's why, for example, my questions in jury verdict sheets, I always try to frame them so they fit my proof. Because then I'm just echoing again, reverberating in the juror's mind, my best issues and my proof. So, there are so many different ways to affect that process. That's just one.
Well, let me ask this, Mark. Okay, for our lawyers that are listening to this podcast, they have a case. How do they even start the case framing process? What goes through your mind? Number one. Number two, what do you mean by I can't just get over it? And number three, what are echoes? I know this because I've worked with you so long and I've read your books, but I just want to get to the basics.
So first, everything you do, this is just my feeling. So I don't think I'm wrong, but of course I can be wrong. Everything you do, everything a lawyer does from the very first second they start talking to the client should be within case framing. All right. But it isn't just at trial, is my point. In depositions, just to give you an example. And I actually read these rules and I study this stuff a lot and have over the years. When I first started, if there were 3 defense lawyers and me at a depot, the first lawyer would go. They were deposing, say, my client. The first lawyer, defense lawyer, would go. Then the second one would go. Then the third one would go. And then the first one would go again. And then the second one would go again until they ran out of questions, right? And I said, well, that didn't seem right. And you know what? In Rule 30C, it says depositions will be conducted just like trial. Now, at trial, if the first one goes, the second one goes, and the third one goes, and I don't have any question, that's it. So I started saying when they finished, and then the first one started again, I said, wait a second, you can go to court if you want, but 30C says this deposition's done because I didn't ask any questions. That's framing. That is framing. I can give you example after example after example of how that works in like judicial admissions, judicial estoppels, how to use curative instructions. So you need to be thinking from day one about all of this. And I just can't get over issue. They're the things that when you hear them, you say to yourself, I just can't get over it that jerk said that or did that or whatever. I can't get over it. And the thing is, when I go out with a vet, she says, "Oh, Mark, you think they're saying that they read your books?" And I said, "No, no, no, no." But the point is, you'd be surprised how many times you'll hear people say, "I just can't believe, like, this guy said that, or that person did this, or something." That's what drives juror decision making. What people just can't get over affects how they decide what to do. How they decide, do they like that person, respect that person, want to follow that person, or not? And they usually are liability issues like wrongdoing, you know, can't believe, they had these toxic chemicals in the water. But they also can be on causation. For example, you have a client who says they're seriously injured because they slipped and fell or something else, and they don't go see a doctor for 6 months and then they start seeing a chiropractor. That's an I just can't get over issue that isn't good for you.
Right.
Because if they were that badly injured, they'd have gone to see a doctor that day or soon. I'm not saying it's always true, but those issues strike a responsive chord in people that it doesn't seem intuitively that that's a good position. Or it could be that they totally agree with you and it's a good I can't get over issue. We had a case once for it was an obstetric case, badly brain damaged little boy. And at 28 weeks, his mom had diabetes. She had an episode of diabetic ketoacidosis, very serious. She survived. He was 28 weeks, but she took him to the hospital emergency room because she didn't feel well and she wanted her baby to be all right. And this resident in the emergency room just blew her off and sent her home after she waited for 3 hours, saw him for 5 minutes, sent her home. And then 2 months later, he was born, one of the worst brain injured children I've ever represented. And he died when he was 11. But what we did was we had a good negligence proof, but our client didn't do well in her depot. So it became a tougher negligence proof. But there were some issues on causation that were so much more in our favor than their favor that I said to Yvette, if we can win the causation issue, the jury's going to be much more likely to believe us on negligence. It'll slough over. And so the case frame in that case became timing. Now, why is that an overall case frame? Because everybody knows life is a matter of timing. If I had just, thank God I didn't get on that plane that then crashed. If I had just been there 20 minutes earlier, I'd have been on that plane. Everything is a matter of timing. And that's an aphorism that strikes a responsive chord in people. Why is that an issue in that case? Because the resident, when he charted the chart, in obstetric cases, they have these numbers, 2, 1, 3, and it means how many pregnancies, how many abortions, etc. And the last one means how many children are alive living with the mother at home. So this resident put in there 1. Our client had 2 kids alive at home. So he was totally unprepared for this cross at his depot because I knew he wouldn't be thinking this. And I asked him, I went down the line of numbers, and finally I went the same paradigm. Did you write this? What's the basis? You sure was? So I got to the last one. And I said to him, Doc, did you write down 1? What does that mean? I knew what it meant. It means she had 1 child at home. I said, Doc, do you know she had 2 children living with her home?
Oh my
He
God.
said, well, maybe she made a mistake. Maybe the kid was adopted and she didn't want to say it and stuff.
Wait, he said that?
And my daughter was adopted, my first child. And
Right.
I was so offended by that. But I kept my cool, self-discipline. And then I said to him, Doc, are you honestly telling us that any mother doesn't know how many children are alive and living at home with her? And he said, well, maybe she made a mistake. And that case was over. So because I won on causation in that case, we carried the day on liability. But you can also have them on damages. There can be overall case frames, and I just can't get over issues on damages. Jurors just can't get over. When you hear about a wonderful plaintiff, juries just can't get over that. Doesn't mean you're going to win, but it can be decisive in a case, particularly the opposite, unfortunately, too. So that's what there are millions of examples. Selling expired medications. I mean, there's just so many examples of I just can't get over issues.
And as I understand it, Mark, you have the I just can't get over it, those that are good for you, and the I just can't get over it, those that are bad. And you've helped me
Right.
so much realize I need to focus as much on the I just can't get over it negative issues as the positives. So help us understand how you deal with the I just can't get over it that are bad for you?
It's a great question.
Do you hit it head on? How do you work through that?
So what I try to do, and what we do here, is we try to deal with them and get the answers before trial. Much better, obviously. And I came up and I wrote a chapter in my second book, I think, on 15 ways to overcome bad issues.
Okay.
So the first three ways are use overall case frames, I just can't get over issues, and echoes, because they help you overcome the bad issues. For example, you know the birther issues that Trump raised with President Obama. And so what would the answer be? What's the best answer? Would it be for Obama to say, I'm not Muslim, and that's it? And so I would tell you, I don't think so, because people don't hear as much as we think they do. They don't hear the word no enough. For example, if I were to say to you, Charla, in the waiting room of the doctor's office, there was no 95-pound, white-haired, shaggy-haired, growling, drooling, barking dog. You're not going to have the image in your mind that that wasn't there, a blank. You're going to have the image. I said there was no dog like that. You're going to have the image of the dog. You're going to have the image of the dog in your mind. So
I really did. I really did. Okay.
it isn't enough to say, I'm not Muslim, because the issue, the word they're going to hear is,
Muslim.
the words are I and Muslim. So what he has to say is, I'm a Christian. I'm not Muslim. So, and that's what case frames, I just can't get over issues, and echoes do for you. What are the other ways? Motions in limine. So I tried this case in 2012, a malpractice case. And before that trial, because I always research the defense lawyer as well, and one of my friends had tried a case and lost it to this lawyer who had lost 3 cases before, and he was in his 60s. So he was a very successful defense lawyer. I don't know how many he lost, but that's what he said. It was just a few, right? His firm said that. So one of his shticks, one of the things he did, was he would say to the jury in closing, look, you can't blame this doctor. He doesn't have the hands of God. He doesn't have the eyes of God, And then he would say, I'm just saying all this because I want to make sure we're reading out of the same hymnal and the same pew. All these religious references. So I filed a motion in limine to affect the framing and the content that was ever put in front of the jury. And I asked the judge to keep him from doing that because the standard of care was what the average reasonable practicing physician would do, not God. And that's an impossible standard for me to beat. So the judge, in granting my motion, she overstated it a little bit. I don't think she meant it this way, but she said, God will not be in this courtroom. Well, you won't be talking. And of course, we knew that, but I got the message, but she kept it out. We had a client who was a nurse, and the jurors, focus group jurors that we had, were very hard on her, especially on informed consent, even though the case was about surgery and she was a pediatric nurse. So she not surgical.
Right.
And so I moved to keep out she was a nurse because it was prejudicial and not relevant. So they came up with a very creative idea, the defense, and they said, well, look, she drained where the cancer was in her face at home. And if we don't tell the jury she was a nurse, they'll think our doctor was negligent for letting her do that too. Negligent also in letting her do that. And so you have to think quickly. So I got up and I said, Judge, we'll tell the jury that a nurse did it for her, but why does it have to be her being the nurse? And the judge granted, and he kept it out. So a lot of bad issues we keep out and overcome bad issues through the use of motions in limine. And then we have to make sure we don't violate that. One other example I'll give you, and then they're in my book, the 15 ways. But I tried a case a few years ago, and it was so hard. I mean, my friends, I did it as a favor to a friend. I tried the case.
Aren't those sometimes the worst?
Oh, well, this was so hard. I had no chance of winning this case. None, zero. I asked our friends in the inner circle, and everybody said, Mark, are you insane? This is ridiculous. But one of the difficulties I had was it was a dram shop case. And my client lived with the drunk driver, had a child with the drunk driver at the time of the crash, and had another child with him, and she was paralyzed, and she still had a child with the same guy. And they lived together at the time of trial. So I was concerned that if I didn't keep the money from him, I would lose. There's no way I could win it. It was just one of my bad, and I had more bad issues of it than I've ever had in a case, in that case.
That I can't get over it's that are on the bad side.
Almost all. But what I did was I said, I've got to deal with this. So a year before trial, I set up a Medicaid special needs trust. Now, I don't know. I've never done that before. In my experience, we only set those up after the case settles
Right.
because the client, in setting up a Medicaid special needs trust, relinquishes all control over it, or she can't, or he can't control that money. So I did it, and my client trusted me that she couldn't win otherwise. And in the trust, I had three provisions. One, that he could never be, the drunk driver could never be the trustee, even though his kids would be beneficiaries. Two, there would be trusts set up for each kid that would last until they're 25. So if at 26 they want to give their father money, fine.
Right.
And three, that no money from that she got, our client who was paralyzed, he would never be able to get any of that. And then I filed a motion pre-trial. So it's not a motion in limine, it's just a motion pre-trial to have the grandparents who were the co-trustees of that trust made plaintiffs. And then I made that exhibit.
Mark, that is brilliant.
And I made the exhibit number one, the trust. And then I argued to the jury in closing, you don't have to worry about him getting this money. Grandparents control it. Here's a trust. It's an exhibit. Look at it. He can't get this money. And then we got an 8-figure verdict. That it's a case that no way was I going to win if we didn't file that. So you can overcome bad issues, but I talk about the number of ways to do it in the book, but don't give up. There is a way to overcome almost every bad issue. Now, if your client, if your client, God forbid, was a pedophile and they're in prison for pedophilia and stuff, you might not be able to overcome that. But
I bet you could, but I couldn't.
No, I don't think I could. But the point I'm trying to make is that all you have to do, if you really do case framing, and again, this is just my opinion, so I'm nobody, I could be wrong. But the point is, all you have to do with a defense, a bad issue, is just dent it. Because the way it works, so we can see it work, is if you dent it, then up into the courtroom are your good I can't get over issues that permeate everything. And the bad issue is stopped, is dented. It isn't just, you don't have to destroy it. There's a reason it's almost better to dent it than destroy it. Because if you cross-examine 10 people and crucify 9 and beat them and destroy them, but you don't do it to the 10th, you think you've done a great job, and the jury's saying, well, maybe number 10 is right because he didn't destroy him, right? But if you dent it, and it's great if you can destroy everything, bad for you. But so I'm not saying don't aspire to that, but those are just some of the ways you can overcome.
Let me ask you this, Mark. The negative, I just can't get over it issues. Should we as plaintiffs lawyers bring those up or wait to deal with them as the defense brings them up?
No, I definitely think you have to bring them up.
That's what I thought.
I start. Now, if I get a 30-minute voir dire, which is ridiculous, all right, but if that's what I get, or an hour, the two issues I have to make sure I cover that are they should be case decisive. I have to cover the worst issue for me in the case, the key bad I can't get over issue. And most people think you only deal with the negative issues, but I also deal with the key good I can't get over issue for me in front of a jury.
In voir dire.
Absolutely. And the reason why
we call it voir dire in Texas.
Yeah, voir dire, right? Voir dire. The reason it's everybody agrees you take care of the bad issues because you want to see how a jury would react to them and see if they can be fair. But you also need to test your best issue because if the juror can't respond to it or they don't relate to it, you lose the power of that issue. So you need to have those two issues be the issues you have to address. You always start with the worst one and then say, look, now that I've dealt with that issue, I think it's fair for me to deal with this issue. And I do that also in terms of asking juries in voir dire about money. Because I'll say, look, if we don't prove our case, if we just don't prove that Dr. Smith did this, caused this to Mrs. Jones, are you all willing to say, to vote your vote for a verdict and say you don't get any recovery? Zero. Now, Charlotte, I've never had anybody say they wouldn't give somebody a zero, right? But then I say, on the other hand, if we do prove our case and we show that this harm to Mrs. Jones has value between 25 and $50 million, would you be willing to vote for a verdict? And then it's so, but that's how I do voir dire.
I love that.
But so you have to. And then in opening, like I said before, I make sure I exhaust my good issues, starting with my best, second best, third best, fourth best, and then I'll inoculate against the bad ones. But you got to inoculate against the bad ones, because you want, when they raise it, you want the jury to say, yeah, but Mr. Mandell talked about that, and what about this? Verbal, I mean, inside their own brain.
I got to tell you this, Mark. A long time ago, there's this longtime criminal defense lawyer in Dallas who said, Charla, do you ever get the Bible quoted to you? And, I was the daughter of a Pentecostal preacher, so I really do know the Bible, good, bad, or indifferent. But he would always say, if a lawyer quotes the Bible, you get up in rebuttal and you say, when I was a little girl, my granddaddy told me don't trust any preacher selling real estate or lawyer quoting the Bible. That's a pretty good one, isn't it?
Oh, it's great. I actually do quote the Bible, but
No, I do too. I do too. But if they ever quote it against me, I may use that.
Absolutely. Perfect.
Let me ask you this, Mark. Do you use focus groups? And if you do, how do you do those in conjunction with case frame?
So I do use focus groups, and I also use surveys. All right. The difference is focus groups is a very small number of people, 0 to 12 usually. Surveys can have 500 people, 1,000 people, and they're done by outside agents, consultants.
Right.
With focus groups, what we do is we have the 10 or 12 people there. One of us will make the presentation and by the way, we pre-screen them to make sure nobody works at the hospital and those things, but we'll make a presentation of the plaintiff's proof. And we have written questionnaires we have them fill out before and say after the plaintiff's proof.
Do you do those in-house?
Well, we use a survey center. We don't have a focus group, but we do them at a place that has a mirror you can see through and they can't see us. And after the plaintiff goes, we ask them to fill out written questionnaire. For example, what are the 3 things you remember the plaintiff's lawyer said? Because what they'll tell you is what the most important issues are, right? What you would need to hear to further, what you want to hear further. So a number of questions. And then a different lawyer from our firm will do the defendant side. And then we'll do the same. And then we'll ask the jury to deliberate, these people, and then they'll deliberate. And we ask them liability issues, to deliberate who wins, who loses, and how much, even though it's not predictive to any specific amount, but it gives you an idea.
Right.
With surveys, it's different.
That's the big data surveys?
Yeah, the big data surveys.
Like John Campbell.
And I use John. I work with John. I have tremendous respect for John and his wife.
I do as well.
And I've been working with them for years. I know you have too, of course.
Right.
And I'll do 1, 2, 3. My record with John is 5 surveys. I think I did 5, maybe 4. But
in one case?
One case. And the reason why we did, I think it might have been, it was, I think 5, but it could have been 4. The reason we did so many, Charla, was it turned out to be a great case, but we couldn't figure out the case. We knew the issues. And I ended up using a demonstrative that got over almost all the bad issues for us. It was a rare aggressive cancer. And those 2 words in a malpractice case are usually almost impossible to overcome.
Right. That means you're dead in the water usually.
Right. Exactly. So we overcame that. But I couldn't get, no matter what arguments we made, we couldn't get over a 50% win rate. All right. We were always underwater. And so I said to John, look, I know this is so counterintuitive, but that's where I live, partly. I said, let's do a survey and not present the defense. Let's just make it 100% bias for the plaintiff and see if we can get over 50%. I need to know, is this case even winnable?
Is it winnable? Right.
Without a defense.
Okay.
And we did, and we got it over 50%. And then I was able,
How
we
much
were able,
over 50%?
well, okay, I don't remember, but I think it's safe to say it wasn't overwhelmingly over 50%.
Okay.
It might have been, I don't even think it hit 60, Charlotte, without a doubt.
Wow.
But we figured out the case as best we could. They're not predictive either. And ultimately, look, I remember I was arguing this, doing closing argument, trying to figure out, and partly where I practice, we can ask for a sum of money. You know, some places you can't, we can't. I plan to ask the jury for $3 to $5 million, right? Now today, it would be much more than that. But back then, it was 3 to 5, which was a lot of money back then. And literally, Charla, about a minute before I said that, I'm not sure how I could think this and then still talk what I was saying. But I said to myself, it's too little. Ask for 5 to 10 to myself. So I asked for 5 to 10 because I thought we had proved that. And the jury came back with 10. Right?
Oh, I love that.
So that what I didn't realize was I had spent only 5 minutes on damages in my argument. And my judge told me that later. And I said, Jesus, I had no idea. I would never spend such a small amount of time on damages. My point in saying that is when I say focus groups aren't predictive, surveys aren't, they're not predictive. They're very helpful guides. But I couldn't even predict how much I should ask for until I was giving the middle of giving my closing
And you
argument.
felt it. You just felt it.
And then I felt it like you do, like you do.
It's so much of it is on gut and how you feel. God, there's so many things I want to ask you, Mark. I'm truly, truly enjoying this. But if you were going to give a piece of wisdom to trial lawyers, including young trial lawyers out there, or aspiring trial lawyers, what would you tell them?
Can I give two?
You can give as many as you want.
People say to me, what do you think the best quality is of a great trial lawyer? So I say, well, I don't fit there, but I'll tell you what I've observed. And they expect us to say charisma or even intelligence or discipline or hard work or something. And what I would say, first lesson is try to really understand yourself so much you can be honestly humble. Because I think humility is the greatest trait a trial lawyer has. Because without humility, you can never see the good people around you. You can never really, well, the reason why you can't is because it's always about you if you're not humble. You can never really see yourself because we're never what we have been conditioned to be. We're genuine people living that life. And equally importantly, without humility, you can never, ever, ever, ever learn from the mistakes each one of us is inevitably going to make. All right. So one is, and I'm not talking about humility out of insecurity. I'm talking about like your humility, genuinely heartfelt in your soul. And then the second lesson.
Okay, I got to say this first. You got me in tears on that one because I think that is so, so true. Thank you for that. And what's the second one?
Second one is, and again, it's not a strategic thing. That please read the books. And I learned this, and it's hard because losing is death, right? To me, it's not like dying; it is death. I have to become reborn again after I lose, right? But even with that being true, my advice to any young lawyer is nothing other than, and I don't even want to put my family, your family into it. No case is worth you sacrificing your integrity, your sense of ethics. It isn't worth it. If you have to sacrifice your sense of ethics to win a case, and I'm not saying lose, I'm saying find another way to win.
Oh my gosh. I love that. I love you.
I love you too.
I got to ask you this. When is the next case framing book coming out, Mark Mandell?
I don't know. I do lectures, I will do podcasts, I'll do lectures. I don't think I have another book in me.
You have already given to us with the books you've written. I literally have them on my credenza. I have them tabbed.
I
Mark.
actually stole them, Mark. They're in my office.
Oh, my daughter said she stole them.
I'm
I
hiding them.
I had them in my office like 3 weeks ago.
Yeah.
Did y'all really?
Yeah.
My books?
I just
Yeah.
flip through it and I tab it and it helps.
Charla, can I send you another set?
Yeah, Mark, yeah, please do because
I
I
will do that.
literally they're highlighted, they're tabbed. I didn't know Eleanor and Caleb had stolen them, but when I'm getting ready for even just a new case, I start reading them and read them over and over and over again. So you have given so much to our profession just from doing that. Don't shake your head. It's the truth. You're like me. You don't accept compliments
It's
very
hard.
easily.
It's hard, yeah. Let me
I know.
compliment you.
I know. I don't like that either. Oh my gosh, this has been a highlight of my month, year, decade. Thank you for joining us.
My pleasure.
Caleb or Eleanor, anything else y'all have to add?
Just make sure you sign them, Mark. We got to have the
Oh,
celebrity
I definitely
signature.
will. I will.
The only thing I'll add is I wish we had time for a second episode because I had like 20 more questions.
You got me thinking, Mark, as I sit here about each case that I'm currently working on, and I'm thinking through how to case frame them. And I might make Charla give me your cell phone number.
Eleanor, a friend of mine who was a great woman lawyer from Connecticut, she's in the inner circle, Kathy Nastry. I was giving a talk in San Francisco, and at the end of the talk, she came up to me and she said, "As you were talking, I was thinking about my cases. What is the I just can't get over issue for this and that?" Yeah, I hope it helps. I hope it helps.
You know, Mark, and you've helped me on so many cases, but one of the most significant ones was the dram shop case. I don't know if you remember the Dallas Cowboy.
Yeah, sure. Was that
They
Brown? Was that the name of the
yeah.
case?
Oh gosh, I can't believe you remember that. Yes, Jerry Brown. And what was amazing about it is, you know, we were concerned because the drunk driver, who unfortunately was his best friend, it was a very sad situation, looked sober in the bar, and he came out of the bar and drove through a construction zone and did it perfectly. And then he was arrested 6 minutes later after a single car accident, and the police officer said if he had tried to leave the scene, he would have arrested him. He was so obviously intoxicated. Do you remember this? I call
Oh, of
you
course,
and
absolutely, of
I
course.
said, "Mark, okay, help me case frame." And you said, "Charla, your first witness is the police officer who said 6 minutes after he left the bar, he was so obviously intoxicated. If he had tried to leave the scene of the accident, he would have arrested."
Absolutely.
And I
Yeah.
gotta tell you, Mark, no question in my mind, we won that case because of your case framing.
Well,
It's the truth. Thank you, my dear friend.
my pleasure.
Thank
Really,
you for being
it's an
here.
honor
Tell
to be here.
Yvette I said hi and that I love her.
Definitely.
Okay.
And that's our most recent episode of More Likely Than Not. If you have any questions or suggestions for future podcast guests, please email us at info@morelikelythannot.com.
They always tell me to say that and I always forget. All right. Thank you, Mark.
My pleasure.
I think you can tell, and we at Aldous Law here, we actually kind of like each other, and we absolutely love what we do. And we work a lot of our cases up from the get-go, but we're brought in on cases a lot. We try cases all across the nation. If you have a case that you're interested in talking to us about, we'd love to hear from you. We've tried everything from trucking, workplace injuries, explosions and burn cases, dram shops, rideshare sexual assaults, birth injury, your personal injury cases. If you need a partner to help you with your case, please call us. We can be contacted at aldouslaw.com. We'd love to hear from you.
You've been listening to More Likely Than Not, where the Aldous Law team turns small margins into massive victories. Love what you heard? Don't miss an episode. Subscribe now, leave a review, or share this with a fellow trial warrior. Remember, we're all just 0.01% away from tipping the scales. Produced and powered by LawPods.